Caput lupinum, wolf's head. In medieval English law, this was not a metaphor. It was a precise legal designation, one with a single, exact meaning. A man had been placed outside the protection of the law entirely. Anyone who encountered him could kill him without legal consequence, not as punishment, not as execution, simply because the law no longer recognized him as a person it was obligated to protect. This is what outlawry actually was, not legend, not folklore. The legal mechanism itself, what it produced, what it meant in practice, and what it reveals about how medieval law understood the relationship between a person and the community that gave law its meaning. To understand what it meant to lose legal protection, you first have to understand what legal protection actually was. In medieval England, the law was not an abstract system that existed independently of political authority. It was an extension of royal power, specifically of what legal sources called the king's peace, pax regis. The king's peace meant that serious crimes were not merely offenses against a victim, they were offenses against the order the king was understood to uphold. To live inside that peace meant being entitled to its protection and bound by its obligations. This was not an individual arrangement. It was communal in structure. Free adult males were organized into units called tithings, groups of roughly 10 men. Each member was mutually responsible for the conduct of the others. If a member committed an offense and fled, the tithing itself could be held liable and fined. Legal standing was embedded in communal membership. You were accountable to those around you, and they were accountable for you. The law was not something that existed above the community. It existed through it. The primary venue for serious legal matters was the county court, presided over by the sheriff, the crown's representative, at the local level. To participate in the legal system meant appearing before these courts. Presence was itself a form of legal participation. It was how a man confirmed his place within the system. This is the baseline. This is what it meant to be inside the law. What happened, then, when a man accused of a serious crime refused to participate? Outlawry was not an immediate response to wrongdoing. It was the end result of a formal legal process, one that gave the accused repeated opportunities to appear before it concluded. The process began with a serious criminal accusation: homicide, robbery, rape, or a comparable felony. The accused was required to appear before the county court. A formal summons was issued. If the accused did not appear, this was recorded. The sheriff was then obligated to issue an exigent of formal proclamation, read at 5 consecutive county court sessions, demanding the accused's appearance. Each reading was a public act. Each silence from the accused was formally counted. Consider what this meant in practice. The court assembled. The name of the accused was stated. The demand for appearance was made. And the accused was not there. This was recorded, and the court convened again and again. After 5 exigencies met with continued absence, the pronouncement of outlawry was made. It was entered into the record, and its effects took force immediately. The system had been patient. The outlawry that resulted was not improvised. It was the outcome of a defined legal process the accused had, at every stage, declined to engage with. The moment the pronouncement was made, its consequences were precise and total. The outlaw had no standing before any court. He could not bring a legal claim. He could not testify. He could not be recognized as a party to a legal proceeding in his own name, and crucially, the law offered him no protection from violence. This is the meaning of times caput lupinum. The outlaw's head carried the same legal value as a wolf's head. Anyone who encountered him could kill him without committing homicide in the legal sense. There was no crime in killing a man the law had ceased to recognize. The consequences extended to property as well. His movable goods were forfeit to the crown. His lands followed a defined sequence. The crown was entitled to a year and a day before the land reverted to the lord from whom it was held. His family was not automatically subject to legal punishment. But the forfeiture of assets had obvious and immediate consequences for any dependents. It is worth noting the gap between formal law and lived reality. The legal erasure was complete, in principle. Its practical implementation was uneven. Enforcement depended on local conditions, the sheriff's resources, and how actively authorities chose to pursue the matter. The legal exposure was total. The actual outcome varied. The royal courts were not the only institution that structured medieval life. The church maintained its own parallel system of belonging and its own mechanism of exclusion. Excommunication removed a person from the sacramental community. A person under major excommunication could not receive the sacraments, could not participate in the liturgical life of the church, and was formally separated from the community of the faithful. Outlawry and excommunication were legally distinct. They operated through different authorities, under different procedures, but they could reinforce each other. A man who was both outlawed and excommunicated was excluded from two interlocking systems simultaneously removed from the legal community of the realm and from the spiritual community of the church. What the outlaw lost was not only legal standing and property. He lost his place in the Frank Pledge. He was separated from kin networks that depended on legal recognition to function. He was cut off from the parish community that organized much of daily social life. His erasure operated across multiple dimensions at once. How, then, did an outlawed man actually survive? The forest offered a partial answer. Large areas of woodland existed at the margins of ordinary jurisdiction terrain, where a sheriff's authority was hard to project effectively. The outlaw who survived did so not through legal means, but through informal ones. He depended on others who chose to provide food, shelter, or information despite the legal risks. Harboring an outlaw was itself an offense. Those who assisted him did so at their own risk. Movement was essential. Staying in a fixed location invited discovery. The outlaw's existence was defined by the need to remain beyond the reach of those who might act on the legal license to kill him. This was not a romantic existence. It was a condition of dependency, exposure, and uncertainty, the outlaw removed from every institutional structure that organized medieval life, surviving entirely on informal connections that could not be publicly acknowledged. Outlawry was not always permanent. The most significant path back was the royal pardon. The king retained the prerogative to restore a man to the law's protection. Pardons were typically contingent on military service to the crown, a financial settlement, or political considerations that made the restoration of a particular individual useful to royal interests. A man might also surrender himself directly to the sheriff, returning to custody of the legal system, from which formal proceedings and potentially pardon could follow. Another option was abjuration of the realm, a formal process by which the outlaw swore to leave England and never return, departing through a designated port within a set number of days. Restoration of legal standing did not automatically mean restoration of everything lost. Forfeited goods and lands were not necessarily returned. A pardoned man might recover his legal personhood without recovering the material foundations of the life he had held before. Step back from the procedural detail, and what outlawry reveals is something fundamental about how medieval law understood the individual. Legal personhood, in the medieval world, was not inherent. It was conferred and maintained through participation in the legal community, through the Frank Pledge, through appearance before the courts, through membership in the structures that made law operative. A man who withdrew from that participation could be formally removed from the category of persons the law recognized. Similar mechanisms existed elsewhere in medieval Europe. In the Norse world, the concept of outlawry, times being outside the law, produced effects that parallel, in their essential structure, what English outlawry achieved. The specific procedures differed. The underlying logic was consistent. The legal community had defined edges, and crossing those edges had formal consequences. Medieval law was not simply a system for punishing those who broke its rules. It was a system that defined who belonged to the community the rules protected. When the law ceased to recognize a man, it was not abandoning him. It was stating, formally and precisely, that he had already ceased to participate in the community the law existed to serve. That distinction tells us a great deal about how medieval societies understood the relationship between the individual and the law, and how fragile, how contingent, and how communal that relationship actually was.